transfer order, my lord. Transfer order has been paid. Now, the petitioner submitted the application that he is ready to go. Monday. Yesterday, Friday, right? I beg to for listing on the meta illness to long-term family pension. Ask you to it's insurance, then says it's not regular. This is the issue, my lord, and they are retired already, 22 members. So 8th of April. For one, what is the petition is transferred twice in a year. Either it. They have to withdraw. Day after tomorrow? Monday. Day after. Day after. Obligation. An item for Friday. What is the matter? Your lordship, your petition is filing a motion. Yes. Fresh matter. Yes, your lordship. Item number 101, hearing this. Second half, if we are able to complete the list, try to follow up the matter. 101. You're referring to 101. 101. You want it today? Monday. Monday can mention on Monday. Monday is fine. Monday you make a mention. Adjourn for today. Item 10 on the request of Mr. US Bora. US Bora. After 1 week, he submitted that consent of the council. I beg you, on item. Let us see. 30 of 36, 31. Let it be on first of April. There's an interim order. There's no interim order. Wait, let us have the matter called up. Let the matter be called up. 37. That may be called for. Why should we call for an affidavit filed yesterday? No, that, but why did you file it yesterday? You know the matter is fixed today. Come on Friday. Other side is not given. Document items 12 and 13. We are required to produce the views of the personal department. From the other side, Lordship, I'll have the instruction by tomorrow. So if Lordship may fix it on Friday, Lordship, I can. Item 12, 13 on the request. Lordship. Submitted consent of the council. Yes, ma'am. For the petitioner is also. Friday. Friday. I'm grateful.
you have been asked to produce some documentary evidence to substantiate that you have been in Gauhati. So I have collected the document, but I have to bring it to some time mechanism.
Mr. Civil Counsel by Mr. J.K. Sharma. By an additional affidavit. Citing permitted time to bring it's taken after the rod or appeal. Tenth of April. 10th April.
Section 11 petition.
Where is the agreement?
The contract is at page number 17.
17.
17 and actually contract between the seller and the buyer is for the supply of goods, service, as available of the unless otherwise superseded by goods, service, specified special terms and conditions and or reverse of resolution of dispute. Buyer and seller has given
Where is the GTC?
goods. I can say that the contract place to be bid public reverse option. Number one, method of dispute resolution will be as per the options selected by the buyer while creation of the bid itself in the time. Guidance for arbitration and mediation in contracts of domestic public.
Anything to submit? Counsel for the parties, issue notice within the 4 weeks. Miss N.N. Sharma, it is on behalf of period of 1 week from today. File their objections, if so advise in the meantime.
And so find the order text 16 minutes, paragraph 9. And 2 6
Era?
Then 9 Roman 2.
Respondent be taken by speed post within 1 week. Just after the return of
I note as per the last order dated 27/2/2026, the respondent was assured the order will provide sufficient allowance for payment. Not yet.
Yes, yes.
So, Shiva, I couldn't connect the consent video.
Huh?
I tried contacting the consent video, but seems like it. And I pray that it will take a second half. By the time
Second half.
but here I am awaiting the instructions. I need further 10 days time.
None appears for the petitioner on call, Mr. Deepak.
Logical is a notice in the matter. It has only come.
Notice, no?
Notice or issued. Huh?
No.
Good. So what is the issue?
Like to remove from the time.
What?
The absence of the council not be able to take steps.
No, not.
Make it like this.
But
like
let
this
it come up
this
with
matter after
Yes.
2 weeks.
After me. Not.
Yes.
Matter relating to non-selection to the petition in spite of that is qualified. The examination as mentioned in page 19 law, the notification. 19 law, then Annexure 1. The Constable GD Central Armed Police Forces and SSF Rifles, GD in Assam Rifles and Sepoy in Narcotic Control Bureau Exemption 2025. All the stages the petitioners have been qualified, including the detailed medical and document verification. After in the final, that is the declaration of the result, some posts are keeping vacant for Assam, but they are not. That is the Lordship page page 38. There is a mode of selection in the last 14 number point, page 13. That is the unreserved 30%. There are total marks to be obtained.
No, 38, page number 38.
Yes, Lord.
Serial number?
Serial number 14, Lord. Mode of selection.
14, yes.
The recruitment process will consist computer-based examination, physical standard test, physical efficiency test, medical examination, and document verification. And candidates scoring the 14.2, candidates scoring the following minimum qualifying marks in the computer-based examination will be considered eligible for shortlisting to the next stage, that is PST examination. So, see, all the stages, that is the petitions have been qualified. And the final result has been declared. And for Assam, so many, that is the posts are keeping vacant. If the qualified candidates are not getting, that is the job. My grievance is that also. Number 13 of my petition, paragraph 9. I have shown the vacancy which are not filled by the respondent, in spite of having qualified candidates. Number 13 of my petition.
Let them obtain instructions. What else? Time you want. Process undertaken for recruitment. I'm rifle. The boy in narcotics control.
Lordship, CRPF is a nodal agency, so they are necessary party.
You raise an objection. Right?
If staff selection has conducted the examination and staff selection has declared the result. That's why we have made
But in
parties.
between Lordship, medical examination, etc., those were by the nodal office.
If required, we'll call them, we'll carry them as part. Because
If I may be paid for a interim protection.
for interim.
At least that is push, though push are vacant, should not be diverted to the other state or should be keeping vacant.
Other state.
Maybe that is the adjusted or something like that. Because push are vacant, not filled.
Lordship, it will be taken care of, Lordship, if they will be successful. Because document, it's not
Interim
only the
protection
merit place has been published, the document verification stage is going. So,
Document verification stage is over.
We'll do one thing, we'll issue notice on your interim plan.
Yes.
Then we'll consider it on the next returnable date, meanwhile let them get their
Yes.
expense.
And the second is
3 weeks. So notice on the interim plan, returnable. 20 April,
yes,
prayer for interim, we consider on the next date. Yes,
the
Lordship-
next is the same name.
next matter.
Time to obtain the instructions, but I can.
No, we are issuing notice.
The next case.
Yes. Next case is similar, isn't it?
Yes, similar, but districts are different.
For taking instruction, where that CRPF and the nodal officer, here the BSF, their document verifications were done. So,
No, we are issuing notice.
there's
Raise
not
whatever
been
objections are there.
Lordship.
Right.
7 I made.
Mr. M.S.P. Sharma in item number 6.
Right.
Second in command in Gauhati. I was convicted 498 cases. Students, annexure 5, case 17.
You're dismissed from service.
Yes, sir. Now the position
You
is.
filed an appeal.
Conviction is- That's the conviction upon which your I have been placed has already been suspended.
No, but have you filed an appeal?
Your Lordship, please, 19 Your Lordship. I have been, Your Lordship, case 79 Your Lordship. Case 79 Your Lordship.
79 of?
79 of Your Lordship, the order, deed petitions.
Huh.
I have been removed by for and on behalf of central government. So, central government is the authority to remove me from the Your Lordship, this post. Now, here 20, Your Lordship, section 29 of the rules. So the highest authority is the central government. If central government remove me, Your Lordship, then where to go, Your Lordship? It is only the weak. And Your Lordship, this order was passed under section 20, under rule 29. There is section 10 of the rule.
Yes, which rule you're referring to?
Your Lordship, I have been dismissed under rule 19. Your Lordship. Medical service of officer by the central government on account of misconduct. It is proposed to terminate the service of an officer under section 10 On account of
Was there a force court convened? Force court was convened. Force court.
Section 10, Your Lordship. Termination of service by the central government. Subject to the provision of this act and rules, central government may dismiss or remove from the service of any person subject to and appeal, Your Lordship. 29. Appeal against order of dismissal, removal, and termination. A person subject to the act other than an officer who has been dismissed, removed, or compulsorily retired from the service shall have the right to put in an appeal against the termination of service to any of the authority higher than the one who has passed the termination order within 90 days of the termination service. In case of officer, appeal shall lie to the central government, and such appeal shall be filed within 90 days of the termination service, where the appeal authority set aside scholarship for the central government. Now, in my case, your central government has terminated.
On the maintainability.
Scholarship, the central government itself terminated.
We'll hear you on the maintainability. Let them get instructions.
But your lordship, the position is now one thing I want to point out. Position B. This, as per this order,
Is there any authority you are relying on that in case of orders like this?
I'm relying on,
No appellate forum is available.
I'm relying on the but your lordship, the position has changed. My conviction was, my dismissal was based on the conviction. I'm reading your page 17. Page 78, where for your lordship. 3. Whereas the Honorable Sub-Divisional Magistrates Bhagalpur, Bihar, by order convicted Sri Brijesh Kumar Singhwal in said criminal case under 498A of the IPC commanded sentence of 3 years imprisonment along with fine fine. Whereas the officer was subsequently granted bail on the same offence. Furthermore, the Honorable Bhagalpur by order has confirmed the provisional bail and suspended the sentence court till the disposal of the appeal. The Honorable Session Judge Bhagalpur has only suspended the sentence, therefore the conviction is still effective. Therefore, in exercise of the power under Section 10 of the SSB Act and 19 of the SSB Rule, central government hereby order the dismissal of so in second income from the service immediately. So, my service was terminated because I was convicted and there is no suspension of the conviction. Your Lordship, I filed the dismissal. Now the position is that my my conviction has also been suspended. So your position on which I was terminated also already finished. This order is now annulled. So if conviction is gone, your lordship, it is a state. Means there is no conviction as well.
Conviction is not gone, it is state.
It is a state.
So your lordship, conviction setting aside and state.
Which I was.
We'll hear you.
But your lordship, the very foundation on which I was terminated.
So it's not over, it's suspended.
Conviction is suspended. So
your prayer is for setting aside the dismissal.
Yes, sir.
Now passing an interim order suspending your dismissal will amount to giving the final.
Your lordship, the foundation is gold. Your
we'll hear you on that. Third, Mr. Counsel for the party. MSN Dharma appears for the respondents. Notices are waived. Extra copies will be furnished within a period of 1 week from today. Same day, the question of maintainability would also be taken. Next. View of the fact that the petitioner contends that there is no forum for filing an appeal under the rules, act and the rules, in view of the fact that the order of dismissal has been issued by and on behalf of the government of the state. matter again on 23rd of April.
One second. Sorry, Your Honor. Now, I have this operative asking me to.
If the next date fixed, the petitioner shall not be, no coercive action be taken against the petitioner regarding vacation of the official quarters that he is residing, that he claims to be residing in presently. Huh?
25?
25?
Let me fix on 25.
25th of April is a Sunday, Saturday,
Then Monday.
not Monday. We'll have it on 28th, Tuesday. 28th of April.
Find out the job. I did with DRDO. Was related to
MBA. Is it MBA? No.
JRF.
JRF undertaken during a full-time JRF. What is the instruction?
My inspection, if you're asking for my inspection.
I think you were permitted to obtain instruction. No?
Yes. As per DRDO person, this is not related to anything. My instruction is that academic roles such as JRF is completely not taken into consideration as working experience. Because what we are seeking here is a on-field working experience, as Lottie can see from page 34.
According to you, it is specified in the advertisement.
Specified in the advertisement, and that particular line, which indicates the working experience, it categorically says at page 41 that academic roles such as, Lottie will see that academic roles such as teaching, research work, JRF, SRF, PhD scholar. All these roles which are academic in nature are to be excluded from the definition of working experience, relevant work experience. Then it further proceeds to say,
no, is it qualified by the during graduation, post graduation?
The qualifier during graduation, post graduation is only confined to the work, project work. It is not a general qualifier. It is a qualifier that is only applicable to the last expression, the last precedent rule, the last antecedent rule also. It is applicable only to project work. Philosophy will read that. I'll just read that sentence again slowly. It speaks about academic roles, which are teaching, research, JRF, SRF, PhD scholar.
What is the post here? What is the post that he is applying?
Yes, that you'll also will find at page 34. This is the post of superintendent engineer, pipeline, technology, page 34, and instrument. Now, if you'll also will see the essential post qualification relevant work experience.
Yes.
Yes, that is reading. Must have minimum 4 years post qualification relevant work experience of working. Actually, the word is working in operation and maintenance of telecommunication system or instrumentation system. So what we are looking for is a person having field experience of working in that particular post. And therefore, while defining the word work experience, we have categorically stated that academic roles, such as those 4 criteria are there, including JRF, will not be considered as working experience. We also include or projects works during graduation and post graduation. So that is a separate compartment altogether. The qualifier, graduation post-graduation, is only applicable to project work. Because there is no comma after the project work. And there is a clear distinction by the word or being put in between.
Yes.
So that is our
qualification
instruction.
for the post was graduation.
No, but you must also satisfy the post-qualification work specified there, page 34.
Worship, pending, page 97, that was a reply given to an application.
No, no. First, let us understand the requirement. Requirement is in page 34. What is page 34? Page 34, the work experience is clearly specified.
Yes,
Operation, maintenance of telecommunication systems, instrumentation systems, or so and so systems in telecommunication industry. Now you want to say that you are working as a JRF. Working as a JRF in this particular field.
yes, sir. That is
Where is it?
Page 62 is his appointment letter. It clearly says that he was working for research capacity. Page 62.
No, research capacity in which area?
That appointment order is at page 62. Now, if you come to page 62, C. Appointment letter would indicate the job profile and whether it was research or working.
It is
Field work.
certified by DRDO Lordship, experience certificate. After for 5 months, 8 months, 20 days, and it is
No. Question is, do you satisfy the requirement of work experience in operation, maintenance of telecommunication systems?
Lordship. That's why I'm referring to the certificate issued by DRDO at page 67, Lordship.
Yes.
Yes. Reading Lordship, it is to certify that Mr. Narasimhan worked as junior research fellow from 20th May 2021 to 3rd of February 2022 with the organization. During the tenure, he has worked on failure mode of effect analysis and reliability estimation of electronic components and systems for various armament applications. During
No, but
this
is this the desired area of work experience required for the job?
Lordship,
How do you
no,
correlate?
They have not come up with that, but in the reply, they said that
This work experience under DRDO was as what, JRF?
JRF, yes,
JRF.
Lord.
Yeah,
The appointment letter indicates that.
yeah. So it is important, Lordship, at page 97, they say, however, it
JRF
is
is completely excluded. Lord.
explicitly stated in the advertisement that academic roles such as teaching, research work, JRF, SRF positions, PhD scholars, or public assignments undertaken during graduation, promotion, PhD shall not be treated as valid work experience. This has not been found in the advertisement. And giving the reply only, they have resorted.
How many years of JRF you have? 2 years.
3 years. 8 months.
8
not
months.
years.
No, it is 2 years. Page number 62. Number 62 is for a period of 2 years.
But I think it didn't serve for 2 years.
No,
Because
it is appointment was for 2 years, but he left early.
He left early. So how do you satisfy the 4 years requirement?
4 years taking together other experiences.
What other experience?
there we have no dispute regarding the other experience. We are not taking into consideration this 8 months because this is under JRF. This is the academic role.
That is my grievance.
And that is why
Because
we have
that
excluded it
threshold-
as per the And the threshold
advertisement
specified
terms
all
and
the
conditions.
So the question is that you have to satisfy yourself as an authority for selection of the candidate, whether he has the knowledge of the work experience that you have
What we are
specified.
saying,
Now,
academic rules.
No, no,
We have
academic,
identified ARF as an academic rule because this is
there
a
must
research
be,
rule.
there must be a reason. There must be a reason. I'm sure you have that in your report.
I can find my affidavit on this.
So please hear,
My instruction as of now is
hear the question of the court.
yes.
There must be reasons for excluding JRF, SRF, PhD. There must be a reason. It may be that this does not relate to the work experience or the criteria specified,
Right.
whatever it may be. But supposing a candidate has the exposure, should it be a ground to simply reject it? Mainly because you say that JRF, SRF, PhD, there must be a good reason why you are excluding these scholars.
A technical answer to that would be terms of the advertisement is not open for challenge today because he has already participated. And the terms of the advertisement clearly say
just to know why you have given these terms of the
therefore I say it's a technical. I'm not saying that it cannot be entered in.
So, if it is a case that notwithstanding that his case has been considered and it was found that his experience in these 8 months is not relatable to his 4 years and therefore it doesn't satisfy. One way to approach, but the other way to say that no PhD, SRF, DRF, what is the meaning of that? For what purpose?
Because if your lordship will see the advertisement again,
No,
just
we
for the cost of
conscious.
repetition.
We are conscious of your.
Yes,
we are only asking you the reasons why this particular clause is there.
Because they
Because I'll tell you why.
Yes. Have identified JRF as an academic rule. Therefore, it says academic rules such as. So we identify JRF as academic.
You cannot identify JRF, SRF, PhD as an academic rule unless
this is the term of the advertisement.
No, unless the certification says so. They are scholars. They are undertaking research.
In a particular petitioner indicates that it's a research.
Research.
Now, it's not field work.
Only because it is research and not field work. Because research may relate to field work.
That we not know, but the appointment letter itself indicates this is research. And what we are looking for is
like
field work.
It's like saying that a person who is otherwise qualified in law is not
practicing.
It's not capable of being, is not permitted to practice because he is involved in research.
Not as such, but he is graduate in law, but not practicing, and therefore he cannot apply for a particular post because that experience is not there.
No, that's right. But whether the experience he is gained in the research work is relatable to the experience you are looking for, that's the question.
My humble submission.
You are right that the advertisement is very rigid, very strict, and there is no challenge to the advertisement. I will be asking you. This is the public sector undertaking. Your job is to pick up the best. So pick out people merely because they are involved in academic pursuits, or is it because you have undertaken their selection and found out that no X, Y, Z reasons they are not eligible or they do not satisfy the requirement?
As a PSU, the selection committee is following the terms strictly. Because tomorrow, if there is some leeway given, that may be also treated in a different manner or constructed in a different light also. That a leeway has been given to someone while the
selection body of a public sector undertaking is imposed with more responsibility. Select the best because it is a public sector undertaking. Within private company, different.
Within the conditions of the advertisement.
Right. So therefore, examine it and
I'll file my affidavit. 10 days time, I'll file my affidavit, and this issue can be gone into.
What has happened to the posts?
Already, one has joined, and one has joined. The other is going to join on 1st of April.
Then either of their appointments will be subject to the outcome of the day.
Subject to outcome.
Unless you say that.
But then they have not been in a party. Ask me. But I have informed the last occasion also. Appointments have taken place.
There is no vacant post. How many posts were there?
One post is still vacant. It was not filled up because of want of people.
That I don't have exactly whether it relates to his category of post, his schedule.
Where is the result?
For admission hearing, I'll file the
Sharma,
decide.
Learned Council represents the pipeline within the pipeline P and I. Got to be filled up by way of number so and so dated 18/7/2025. Satisfying essential post qualification relevant work experience. Authorities by referring to the terms of the advertisement. Experience under that he had rendered services under the DRDO, TRF, and which considered by the ODP academic role and therefore excluded from the relevant work experience in the course as per the terms of the advertisement. Senior counsel, Mr. Sharma, assistant by General correct? The academic SRF from a PhD or project work undertaken where are undertaken by the concerned candidate, as is the case with Scotland authorities directed to re-examine the case. Academic narrative by General DRDO academic. Therefore, that period is excluded by the minimum. However, submits that would like to complete with instructions in this regard and file necessary affidavit. Mr. Sharma submits that other order one post is available. That post under page 90.
That post pertains to only unreserved. He is a OBC category candidate.
But there's all the qualifications.
No, how could he has applied under OBC, how can he block a UR unreserved post? Let the let OBC post be subject to outcome.
That terms of the result sheet declared, there is one post available, the unreserved category, which is not been filled up before one. Therefore, that post kept vacant, not been filled up. candidate, whereas the petitioner
Apply for OBC
category.
that is already
Correct.
filled up.
And OBC category. Therefore, OBC categories have already been filled. That means one post or one reserved candidate is available. Question of whether they can be filled up by an OBC category candidate like the petitioner. Decided. If we can, they shall not be filled up in the
Instead of making it until further order, Lordship will fix it for the next date because this is an unreserved post. Lordship has
until further orders. Next day you convince us, we'll negate it.
Lordship will give it for a particular date. I'll file my affidavit and on that the matter can be taken up
All right, in the next day, fix.
till the next day.
It's taken on 7th April. 27th April.
Yes.
Third, counsel for parties issue notice in general for which Mr. H.S. It's since Mr. H.S. Roy. Instructions and file necessary affidavit by the next week.
My lord, the government was to obtain the instruction. That I have received the letter from the chief engineer, my lord. Says that it's further 2 weeks time, my lord, to send us instruction. It's what kind of.
Weeks time.
In the meantime, I should continue to get the pension. That will amount to giving final. No, other bit. That is what that will be interfering with the governor's order.
We will give you 10 days. You complete your instructions. You wait for another 10 days, let us see. That third, Mr. Ken Chaudhary, should be issued notice.
Yes.
Then you'll have to give him 2 weeks. Mr. Ken Chaudhary, counsel, senior counsel, is by Mr. R.M. Data appears to the petitioner, Mr. Art Hall, then an additional senior government advocate appears for the respondent. Mr. Hall submits that by the time issue returnable 2 weeks. Respondent will complete their instructions and file necessary affidavit if so advised in the meantime.
Second of April.
After 2 weeks, 2nd April.
Yes.
2nd April.
April.
After the same of it, time to obtain instruction. There is
Any instructions?
actually our letter went on 13th day. So this speaking term previous as fast.
Mr. C.K.S. Burwal and a government advocate please for further time. Mr. D.K. Das appears for again after weeks. Matter be listed again on 8th of April. Till the next date fixed. Order passed by me.
No India order.
No interim order. Transfer order shall not be given to effective.
No. That he obtained that. I think notice is
All right. Notice required to be issued. You are supposed to get instruction.
sometime maybe.
So we have granted you till 8th of April.
Can manage the.
You have the earlier order, 13.3.
Yes.
Do you have it with you?
No one.
Last line says transfer order shall not be given effective. And you are saying there is no interim order.
Payment.
You don't have the copy of the order.
Okay.
Right. Upload one. Yes, 6th of 8th of April. After some time today, not possible. You have it on Friday.
There is urgency. What had happened? A wrong statement was made by Mr. Gugoi the other day that the other person had joined. He has not joined.
But we have already given you protection. No
No,
coercive
no.
action.
Only coercive measures because the limited they issued a circular. That I understand.
Then we'll call it up at the end of the list. Motion matter.
Yes, come.
Yes.
My lord, I have the records.
Forest councils are always lost because of the department concerned or what?
No, this is
Take time
excise.
to-
Sometimes there are so many
This is
cases.
excise, even worse.
There are so many cases listed, man. There are 35 cases. Sometimes.
This is excise.
Of course, we know you're a lighter side.
So much.
Judges should be permitted to have some lighter side, lighter moments. Yes.
My lord, their basic ground is that, my lord, violation of that OM, my lord, the transfer has been made, and it has no connection whatsoever with the guidelines of the election. My lord, there is a page 41, my lord. So this is a whole OM, my lord. That, my lord, 13, another OM was almost in tune with the earlier OM.
3 years, it is 2 years.
So now, my lord, that normally person should not be transferred before 2 years, and it has to be transferred before 2 years. The concurrence of the Honorable Chief Minister is required. Here, in the context of these OMs, my lord, there is a judgment of the Honorable Court.
So how many years he has completed?
14 months.
14 months. So which is less than 2 years.
Yes, less than 3 years. But whether this guideline is, my lord, binding or
Guideline has to be binding on the department.
precisely, but there is a judgment of the Honorable Court, my lord, that this guideline is not binding. It is a guideline for the government, but it will not give any right to the petitioner.
Absolutely. But you have to explain why the
That I
guideline
will
is,
explain.
the guideline binding on you has not been followed.
Yes, that I will explain. In fact, guideline has been followed.
There is no quarrel that guidelines don't give any enforceable right.
Yes.
There is no quarrel on that.
Yes.
But you have to explain that once a guideline is issued by a higher authority, is it not binding on the subordinate authority? It is.
But when deviate, my lord, that will not give any right to that.
So but you have to answer why you are
Yes,
deviating.
I will indicate, my lord, that there is no deviation. Maybe.
No, there is no quarrel on this. Why are you pressing this judgment?
Okay.
We accept it.
Yes, sir.
There is no quarrel.
If my lord now perishes the records, my lord.
Uh.
Basically, my lord, this petitioner, he has not put in 3 years or he is not in home district. But my lord, sir, this transfer is an incidental transfer. While transferring others, total 65% were transferred. To accommodate those who are to be transferred in terms of election commission guidelines, my lord, this is an incidental transfer.
Yeah, then the lordship wanted to see the record.
Yes, yes, I have the record. I'm just placing it.
That's the most important thing.
It, my lord. He files, my lord.
Lord, we understand, my lord, the election of the minister work, of those who have completed 3 years as per the election commission guidelines, they should be. They should.
Very good.
Well,
One
this is-
district and 3 years.
Yes.
As on 31/5.
Yes.
3 years in the last 4 years.
Yes.
I'm also not disputing that whether petitioner has not put in 3 as well, but his transfer is incidental. While transferring others to accommodate those minors who are to be transferred, he has been transferred.
So the respondent number 4 can be sent
Then you have to have
Gosaigaon.
the sanction of the highest authority.
Yes,
Yes.
yes, I'm coming to that. If my lord perishes this sheet, my lord, page 7, my lord. Page 7 at the bottom, my lord. It may be stated that while carrying out the above exercise of Inspector of Excise, some officers who do not fall under the transfer guidelines of ECI are needed to be transferred. The following proposal in such connection are put up for kind approval. If the above proposals are approved, to accommodate basically, my lord. Then my lord will turn to next page, my lord. That this is the
What is the name of the petition?
Niranjan Das, serial number 2. Next page, my lord will turn. Page 8, my lord, serial number 2. Because of to give effect to the election commission guideline, though these persons are not directly affected, my lord, covered under a guideline, my lord, they have to be transferred out. Then my lord may kindly turn to page number 12, my lord.
What happens after the elections are over?
They'll remain there, my lord. If my lord takes. Where is it? Page 12, my lord. Proposal, my lord. The proposal for transfer. This is the endorsement of the Honorable Chief Minister, my lord. The proposal for transfers necessitated under ECI guidelines are approved. Remaining proposals may be put up for consideration in the month of May.
Then that means they do not fall under
No.
ECI guidelines.
So that was the proposal that these persons are to be transferred out because, my lord, others are to be accommodated in terms of election commission guidelines. Next, my lord, may kindly turn to my lord. Page 14, my lord. Note number 61. Second note, my lord. Notifications of transfer and posting in respect of SC, Superintendent Excise, Deputy Superintendent Excise, and Inspector of Excise have been issued. Compliance report has been sent to personal
It
department.
appears to be exigencies of service.
Exactly, my lord. We have to, my lord, accommodate others, my lord.
Let me explain. Now, respondent number 4 is completed 3 years. How is on this thing? He should be moved out, my lord. Then there is no problem. He can be sent to Gosaigaon, the place where I am being sent. Or it can't be said when the CM
Where
himself,
is
just
the
now my learned friend read
Where
it.
is the respondent number 4, please?
No, Lord, he is from Lakhimpur.
Now,
Now
posted
he has
in
been
Sukia.
brought in my place. He can be sent to Gosaigaon. Then there will be exigencies of service can equally be achieved, my lord.
That is for the department.
No,
You
that's
file
what
a
I'm saying.
representation.
No,
You
Lord,
file your
when-
representation.
No, when the CM says that regarding others,
So
they put up the file in the month of May. That means after 31st of May,
file the representation. Sorry.
yes.
Let them consider.
Yes.
And 15 then will not this claim order will
But
not.
that will because the other person.
No,
has
the other
already
person has not
He
joined.
joined, man. I have the report of joining.
No, no.
The other person has already joined, man.
When?
It will complicate the issue, man. Let him join. Well, one paragraph of a judgment, man. In this situation, one paragraph of a judgment. So then 6(9) SCC 583 SC Saxena, man. Paragraph 6, man.
He will have to go and report.
Paragraph 6, man.
But that is in respect of a person who was on leave.
True, man. True. But wordings are, man, in general in transfer.
Absolutely, we understand that. But you are admitting that this man is not due for transfer,
Yes.
but he's been made to suffer
My lord,
because
we also have
you
to
want
see,
others
my
to accommodate.
We also have to see exigencies. All transfers cannot be inter-se, man. All transfers cannot be
That is
inter-se.
for you to say. You have a set of guidelines. The guidelines are very clear. 2 years. Beyond 2 years, you need
Well,
approval.
let him join, my lord. Within 10 days, we will take a decision. But I will try to impress my client that if possible, my lord, we will accommodate.
Why should you impress your client? If the
I'll
client
ask
take
them.
his own decision, why will you impress? We are only asking you to convey.
That it should not be transferred out.
The decision is for your client to decide.
My lord.
We are only permitting him to file a representation.
Yes.
You may advise your client, but don't try to impress
My lord.
under any circumstance.
My lord.
At least not from at the instance of the court.
I understand. Paragraph 6, my lord, of that judgment.
Yes, we've seen that.
So let him join, my lord, make a representation. Within 10 days, we will take a call.
My lord, then it was submission.
You
Now-
decide it within 1 week.
Fine.
And finish off the matter.
Fine.
He will file a
Milord,
representation within 2 days.
Then let me
Fine.
make the submission.
Yes.
Now my learned friend has said that originally it was 3 years, now it is 2. 2 years also it is permissible. Why did this chief minister give a conference? Now in this case, where is the conference of the chief? The minister said those who have not completed 3 years, those who have not completed 3 years in the home district, sorry, those who are not working in home district, they alone should be moved out. Others should be moved out only after May. So that means, my lord, chief minister's approval was partial. It was conditional. What is the condition? In case of those who have completed 3 years and those who are in home district, they should now be transferred because the EC, that is pursuant to the ECI guideline. Regarding others, place it in the month of May. I just heard my learned friend reading it. Therefore, the chief minister's conference is conditional. So therefore, this exercise is bad. Yes, I may not have an enforceable right, but you are bound by their guideline. Number one.
We had to transfer 65 inspector.
What Mr. Prohibitions says is evident from the report.
Yes, what I'm saying, my lord, before that, concurrence of the Honorable Chief Minister, before that, the note says, my lord, if my lord presented page 7 again, after the list, my lord, it is stated. It may be stated that at the bottom of the page. It may be stated that while carrying out the above exercise of inspector of excise, some
No,
officer,
we have seen that.
yes. So, my lord, in order
But
to
where do you suggest, are you saying that this approval has been approved in toto? No.
not in total, but my lord will also appreciate one thing, my lord. In order to accommodate, my lord, transfer 65 inspector of excise, my lord, some incidental transfers are required.
But that has been approved by the highest authority.
Highest authority, my lord, has said to comply with the guidelines of the election commission. So
And
while complying, my lord, 1% or 2%
remaining proposal
have been affected. This is an incidental transfer, my lord. We cannot make all 65, my lord, interstate transfer.
No, my lord, I appreciate that.
This
when
free
we
play, my lord,
challenge a
this free
transfer
play of the
order, our
authorities are
rights
also
are
required.
limited. But even within that limitation, my lord, there are certain norms. In 5 years, I have been transferred 6 times. And if we count from 2019, then I have been transferred 7 times. Yes, ma'am.
Some free
Yes.
play of the authorities, my lord, to run the
And my lord,
department is
going
also
by
required.
my learned friend's submission, then after the election, in month of May, I'll be again be transferred from Gauhati. So my humble submission is, my lord, I will make a representation as suggested by a counsel. Till then, my lord, this order should not be given effect to, for the very good reason that respondent number 4 has not joined. On the last occasion, my lord, a wrong statement was made by Mr. Gogoi that the respondent number 4 has joined. Yes, till that he has not joined.
This is the joining report status. For making such a claim and allegation, my lord, some portion.
And my client is
But
prepared
for
to
this
swear an
petitioner,
affidavit.
but for this petitioner, my lord, all 64 persons have joined.
That's a different thing.
So the respondent number 4 has also joined.
Somebody may not like to assert his right. That does not mean that's the legal position. It's up to an individual person. My lord, where is that handing over, taking over? He said, under the relevant forms of the Assam Financial Rules. That only is the material to suggest.
subject to my recollection,
Yes.
there appears to be a circular where it says that in case there is no handing over, taking over.
Not to the best of my information.
This is the joining report.
No, he has not joined. In fact,
he is given a joining report under his signature.
Oh, he has given.
Ah.
But the position is Deputy Commissioner has
You have not
permitted
handed
him to
over.
join because of the order of a lordship. Because he has sought opinion from the standing council. Let my learned friend place that. A standing council view has been sought for in view of the order dated 13/3/26. What to do? That's why he has not been allowed to join. That is our instruction. Anyway, my lord, what I am saying is that I'll file a representation. Council will kindly indicate the reasons and let them consider a period of 2 weeks. Till then, my lord, the position as of today should be maintained.
Yes.
So why my learned friend is insisting on that? He
Decide-
knows he has not joined.
Decide within 48 hours, decide within 70 hours.
Yes.
You tell me how much time is required?
7 days. 7 days from
7 days. But Mr. Kane Chaudhary, by Mr. Transfer. According to the petitioner, he sought to be transferred in violation of guidelines which were issued with respect to counsel for the petitioner submits that span of 5 years he was transferred 6 times within the state. And transfer in transfer order transferring you not have been made in terms of the election. All within the criteria specified for such transfer, namely not in home district, nor has he spent 3 years state. Such circumstances, standing down saying excise was permitted to complete instructions on the last date and the matter was paid. So the court tried to justify that the action of the department is not rather directly a person who is not completed transferred out of his place of posting. Might be made. This is of service. Any transfers are required to be made in respect of candidate or other person like the five other candidates. Transferred out. But it's private. Transfer have had as authority state. Any layout in terms of the design of the guidelines, not rights to an enforceable action before submits that the recent judgment rendered by the Saxena, SC Saxena, quoted in its application conduct of not complying with the transfer orders while approaching court, legality of such transfer orders. The importance of transfer. But first, find something submits that where the claim of the petitioner privacy outside the scope of the election commission guidelines and from his instructions, the candidate name private respondent number 4 has not joined this place of posting. Direction to the petitioner by the representation, and until such representation upon the instruction received by the far as the law may cover guidelines cannot be the basis of enforcing rights. Fact remains, these guidelines by higher authority are binding on state government. Comply with these guidelines unless the same as far as the guidelines dated 6th of August 2013. See a transfer respect of respect of satisfy either of the satisfy the requirement that they have been posted in a place and have as far as CA guidelines are concerned. Guidelines lay down the following criteria. Respect of candidates who are required to be transferred out. One, stay in the home district. 3 years. Same district where the officer was transferred. While they are posted in the same district. While in the district. Then satisfies any or all conditions that under the election commission guidelines is required to 6th of August 2013 that person has completed more than 2 years. And in far as the requisition prima facie it appears to the court that he does not satisfy any of the criteria. Stand of the state that his transfer is an incidental transfer in order to promote it. Guideline. Respective submissions made by the company. Permitted to file his representation.
Secretary, madam. That's number two, madam.
Respondent number two, Secretary to the Government of Assam, Excise Department. Within a period of
Days from today. By next Monday. Within 3 days from.
within 3 working days from today. Such an application is filed as permitted by the court. Can be decided within period of 7 days therefore. That is passed by the responsible shall be by way of a speaking order. As far as the claim of the petitioner, as far as the question as to whether the petitioner is trying to point facts and circumstances of the case, this court is not persuaded. Lay down the fact. The directions and also right, that we that the respondent 4 is not joined, which however is then some would be allowed. Third part. Public post. Take back your note sheets.
The 23rd is a Monday.
Uh,
I think it will be 31st of March.
sorry, 30.
30.
30. 31st. 31st would be 7 days.
Yes.
31st would be 7. Huh? You are legal aid counsel.
Fine.
What is the grievance?
Once followed the election 7 and election 9. The
7 and 9.
respondent number 8, 5 to 8, where entity is required to be, and has been considered and
You are in which post?
my lord, now I am assistant executive.
Assistant executive. You want promotion to the higher post.
No, my lord. Thereafter, your lordship kindly see the election 6 minutes 40.
What is your prayer before the court? What do you want?
Yes, my name appears in the notification dated at serial number 150, and subsequent notification, my names appears down below the the names of the respondent number 5.
So you are seeking a correction of the gradation list.
Correct.
Have you filed the representation before the authority?
I have
Where is that?
7
When was it filed?
and 120.
24.
It's page
No, but there is 1/6/26. What is that?
it is subsequent. Thereafter, another notification, two notification. First of all, there was notification 13/2/2020. That notification, my name was correctly appeared. Thereafter, subsequent notification 9/1/2024. My name came down, below the respondent number 5. That is my grievance. Then subsequent, then I filed representation.
From the gradation list,
File.
where according to you, your juniors have been placed higher up.
Yes.
Any further promotions have been made
But
to the next higher post?
9/1/2024, your lordship. Kindly firstly come to page 840, section 6.
40.
Fine. This is the first notification, that we can. My name
You are
appears
in the
page-
post of assistant executive engineer. You are seeking promotion to the post of executive engineer. In the gradation list of assistant executive engineer, according to you, your name has been placed below some of your juniors, right? You are seeking rectification. That has not been given. Now, from this list, in which you are placed below the juniors, have those persons been promoted to the higher post?
Page 44 may kindly be seen.
Why can't you answer a straight and simple question of the court? Yes or no?
Yes, my lord. Page
Promoted? Not promoted?
Yes.
Not promoted yet.
But the list has been published. Therefore, my lord, my apprehension that
So
unless
kindly consider his representation. Where is your representation?
first representation, my lord, page
6 to 64, what is this representation?
thereafter.
Thereafter. You have ventilated your grievances here.
We have initially the 9/1/24.
In your page number 64, have you ventilated your grievances?
17/1/24, my lord, I have first representation.
We are in 26. Why should we direct a representation
No, my lord,
pending
thereafter
for 2 years to be disposed of today?
then last representation, the lordship can be seen. That is at page. Now, my lord, 10. Annexure 10, page 64. Page 64.
This is the representation.
Fine.
We've been asking you. You are going back to 24 already.
One after another, I am, my lord, filing, my lord, they are not.
After 24 event, my lord, another came out in 25, March 25. It's page 58.
Since 24, they are not responding.
Can you get a quick instruction? Or you want to consider?
Let them dispose of my dispute.
My lord, either my lord will direct up to those of the representation forward, my lord to notice. They are a private respondent.
I heard Mr. B.K. Sen, legal aid counsel appearing for the petitioner. And Mr. Hardhor, additional senior government advocate appearing for
1 to 4, my lord.
1 to 4.
That's the private.
That his guns. Petitioner before this court, he belongs to which category? Unreserved. No.
Tribe, tribe plains.
Scheduled tribe plains.
Correct.
Scheduled tribe plains belongs to the Miri community. According to him, his position in the gradation list published by the department in respect of Assistant Executive Engineer Civil under the joint cadre of Public Works Department, Public Works Roads Department and Public Works Building and National Highway Department. Is much below here, more particularly private respondents number 5678. Stop. According to the petitioner, is below the private respondents as his date of birth was wrongly recorded. Stop. He has been representing before the authorities for correction of his date of birth, which has not been addressed. Stop. Presently, the petitioner is apprehending that the private respondents and other persons who are his juniors are likely to be considered for promotion to the next higher post of executive engineer. Stop. Claim of the petitioner that if his position was rectified, he would have been in the zone of consideration for being promoted to the next higher post of executive engineer. Stop. But for the wrong placement of his name in the gradation list, he is likely to suffer his claim for promotion to the next higher post. Earlier, the petitioner had filed representation before the authority. Last representation is dated 6/2/2026. Filed before the Commissioner and Special Secretary, Government of Assam Public Works Department, where he is ventilated his advance. So, the limited prayer of the petitioner being his correction of date of birth and rearrangement of his name in the seniority list, however, require consideration of the claim vis-a-vis the records available with the department. Stop. The petitioner is also added persons who may be affected. And the prayer of the petitioners are allowed, petitioner is allowed, as private respondent in the present petition. So, having perused the petition, more particularly the representation that ends of justice will be met. Number 1, Special Secretary, the Government of Assam, Public Works Department. Examine the claims ventilated by the petitioner by his representation dated and thereafter pass effective orders on the same. One, we'll consider the matters in its entirety, hear the petitioner and all other aggrieved parties, and thereafter pass a speaking order. Stop. If the authorities of if the authority, after considering the grievances, find that the grievance of the petitioner justified, then necessary corrective measures will be undertaken without further delay. With the above observation, it stand disposed of. The petitioner file a certified copy of this order before the authority is concerned, and the representation disposed of within a period of 30 days. 60 days from the date of receipt of a certified copy of disposed.
As my lord, you was one departmental proceeding and one my criminal proceeding. Departmental proceeding with the individual my lord, some two topic of two, and that I have seen in before this honorable court. That is my lord. And my lord, I was acquitted in the my lord criminal. So that's why I filed the appeal. That since I am getting the same set of allegations, that I acquitted in the criminal case, that's why my lord, I filed my lord, that the appeal was rejected. Against that, my lord, I filed this petition. So that, my lord, never been already there is a order in the earlier case also that they have to get from first of the case. So you have to tell issue notice and motion notice, my lord, and they will, my lord, they will tell.
Yes. But
Third one, my lord.
my hearing board.
Five.
State.
One and four, my lord, government. That two angles are government.
Third board. Directed against.
My lord, 18.
6/2025. Passed by the respondent number 2. Rejecting the appeal preferred by C184 of the submits that the petition, same petition is fixed on
First of the appeal.
first of April. Accordingly, prayer is directed state along with six.
Deep job.
One time Mr. B.
Deep job.
I made,
I will BTC. 1 and 4? 1 and 4, yeah.
Acting banking also. We are challenging this suspension order dated 5/12/2025. Also, will get at page 33, whereby the petitioner was deemed to have been placed on the suspension with effect from the date of her arrest, which is 19/11/2020. Okay, we are challenging this order on two grounds. One, lordship, to be suspended under Rule 6 and Sub-Rule 214.
We issued notice today. Third, done down for part.
All respond.
All the respondents. Stop. Thank you. All the respondents. Stop with it.
The cost of 21.
You are challenging the show cause notice
Challenging the proposal notice.
and the inquiry proceedings initiated.
Fine.
And-
And primarily on the ground that the inquiry report and its findings don't state anything about my culpability in the alleged charges.
But you are not challenging the suspension order.
I'm challenging the suspension order.
There is no specific prayer except for an interim order, interim prayer.
My lord will just bear with me.
Anyway, we'll issue notice.
One question, my lord.
2.5 years.
2.5 years without any review being done.
So we'll examine that. We'll examine that.
My lord will just bear with me. That is the inquiry officer. My lord will find that there is nothing to indicate.
We'll have to hear the matter. We can't keep the proceedings.
Just to
Now,
reflect the fact
what has happened to the disciplinary authority has passed an order.
there's no past.
Have you submitted an application,
Yes, ma'am.
representation?
Yes, ma'am. My lord will find it at page
31.
31.
32, 31.
31 is the letter.
Huh?
My reply to the findings of the inquiry, sir.
That's right. Your finding to the
My reply.
before the disciplinary authority.
Not before. Right off.
So your reply means this is your written statement.
So,
Who is the inquiry officer?
inquiry officer.
The inquiry officer.
Page 27.
Uh,
The order. Communication.
by-
Yes, against which my lord I gave my reply.
and
As far as the things are concerned, my lord,
third counsel for parties. There is doctor for respondent 1, 2, 1 and 2. Respondent the representative. Tendency of the writ petition shall not be a bar. Again after the return.
we took the representative.
I'll look at page 17 for a while. 17. Partial modification of this department notification dated showing the of public service, Dr. Sarat Chandra, sub-divisional officer, Guwahati, promoted
temporarily to the post of assistant director. And Lordship may skip my lord, next line, my lord, with retrospective effect, my lord, from 19/5/2017. Now, your Lordship may kindly turn to page 23, my lord. Serial number 11, my lord. Period for which the relaxation of the provision of under FR 17 is required, my lord. This period, my lord, is 19/5/2017 to 31/10/2018, my lord. It is not regularized till date, my lord.
Coming in.
My lord, Prospect kindly see, my lord, he was promoted retrospective effect, my lord.
Yes.
So the period is, my lord, at page 23, my lord. It is from 19/5/2017 to 31/10/2018, my lord. So this period has to be regularized, my lord. That your lordship will see, my lord. Kindly have a look, my lord, at page 29, my lord. And my lord, that the fundamental rules and the subsidiary rules have been annexed, my lord. That 9, my lord, FR 9, my lord. Late promotion and confirmation, where promotion to the higher post was denied in the first instance and later on promotion was given with retrospective effect, the person concerned is entitled to be confirmed from the date from which his juniors have been promoted earlier than which are confirmed.
That order was not passed.
Not passed. In fact, my lord, the Accountant General, my lord, has written to the concerned department, my lord. that was not
Which department is it?
My lord, it is animal husbandry.
Say. What do you say? Notice or we ask them to obtain instructions?
My lord, and my lord,
We issue notice.
my lord,
It's the better thing.
my lord, my lord.
But Mr. N.J. Dr. Lalit Council. Sir? Based on
Tendency, my lord.
tendency of the repetition shall not be a part. It's the grievances raised by the dismissal.
I was discharged. Last time I was studying.
Is
I don't know. So I was Chief, as per prior lordship, they are challenging an order dated for that document of 42. This is only a reply to the legal notice, where it is stated that the person was in the year 19. It's a case of 1992. way back a case of 1990. So it's such a belated stage. Even if this order also 11 April 23, that is also 3 years back. And this is the order they are praying for set aside and quashing. It is only a reply to the legal notice.
Where is that page number?
42.
42. Where is the order of dismissal? How do you know that an order of dismissal is how? Which letter? 42. But that order has to be there.
Yes, that's why, my lord.
You go and file representation asking where is that representation?
Sir, there reply to that. 42 paragraph 4 is clear, lordship.
Oh, but the order of discharge has to be communicated.
That is, they are asking it after 29 years. So our stand is that you cannot be provided at this belated state as the same is not held.
What have you done with the record?
Forfeited his services. Lordship 29 years back record that is as per paragraph 4 of the order is the 11 April.
When were you discharged? 93.
92. That was also not clear. They said
It dates back to 93.
they said in the year 90.
When did you last report for service? For duty?
I was not allowed to join, my lord.
Then what happened after that?
After that, my lord, again I approached the higher authority, can you say next half 4? Higher authority said, let him join and proceeding may be as per law. Then also I was not allowed to join. Then, my lord, I was with after, my lord, several attempts lastly, the year 2025, my lord, they have issued this
From 96 to 22, what happened?
My lord, I am submitting presentation. They have not issued a single letter. Even they said they revert data, and they have not held any court of inquiry.
You have to explain. 96, you have filed your letter in 96, 31 December 96.
My lord, I was not allowed. I went to the main gate. I was, my lord, not allowed to go ahead. And what happened, my lord? I was tried again and again. I approved to the higher authority. Next time, the higher authority said, let him join. Finally, my lord, I asked for pension. They said that, and I could not approach because no dismissal, no discharge, no nothing, my lord. Not a single letter they have issued to me. They are not allowed to join. That is, my lord, spelling factor.
He is entitled to at least to have a copy.
What is now presently they are submitting, that could have been way back in the year 96, 97, lord.
Maybe, but
Why he is
no, assuming he is not asked for it, the authorities can dismiss somebody and not supply the
then
report.
also here also we have asked certain documents. The next page 43, 44. That authorities will provide the discharge certificate and asking for certain documents to submit.
No. Have discharged.
What?
Meaning that you have accepted that he was in your unit for whatever reasons you have discharged. Now is he not entitled to an order of discharge?
Lordship, that order, whether that was issued, whether it was sent, that instruction I have to take. Whether it was sent back, that instruction.
That is the instruction.
Lord.
That instruction. So, can you get instruction in your notice?
Difficult.
But the council was party. That he was discharged from service in the year 1993. Like 1996 had remained pending. I had been discharged. I had been to the national sport. Therefore, question of maintainability decided at the time of admission. Right. Respondent will come to production. Find necessary affidavit to advise. This again after 4 weeks on a date to be fixed.
That was the rules.
Had counsel for parties notice. Hard work. Tips notice on behalf of all. CP scheme. Respondents may complete instructions and file necessary affidavit through. After the returnable date to be fixed. Tendency of the requiration shall not be a bar. Address the grievances of the requiration. Something. Second wife not entitled.
Second one not department may not consider subject.
Second wife not entitled, only children now. Children born out. Where is second wife entitled? Under Muslim law, Mohammedan law. Who is the first wife?
First point may not respondent. First
Seven. But under the full bench judgment also, there is no direction to pay pension to the second wife. It is to be received by the first wife, and you will be bear responsibility of the first wife to ensure the upkeep of the second wife.
department may resolve matters. He approached
Yes, department. Instructions, it is clear that if he lodges the complaint, you will address it, redress it.
Yes, down, that counts lawsuit, whether they have taken any action or not, this I can.
If you have taken action, you supply a copy. If not, then you take it. terms of the full and general.
I think this is very recent, Lordship. Date is not mentioned, but it is
What date?
2026 only, Lordship. If your Lordship,
When
there
did you
is
file it?
page 18, Lordship.
Sent on
Page 18.
3/2/2026.
Lordship only.
But when is the date?
Date is not.
Date postal receipt I have next thing.
Really late.
Copy is there, but copy is not.
Really legible.
Very recent, Lord.
You give us a date on which date. What is the date of your representation?
The petition I have taken.
Before which authority you sent it? Assam, Inspector General.
So, the appropriate authority.
Now
So why should we step into the shoes of the department? The judgment is very clear that the department is empowered to take into account and pass appropriate orders. If the department decides, we should notice.
Lordship. And
I mean-
IGP law is not the authority to
Then
take
there is the
decision.
DGP.
Lordship.
There is
Lordship.
the DGP.
Lordship.
There we go before that the petitioner who claims to be the second wife of late Sheikh is claiming for employed. Are you working somewhere?
No.
Is claiming for 50% of family pension. See by private respondent number 7, who's stated to be the first wife of late Malan. Direction is sought for by placing a reference, by making a reference to the judgment of a full bench of this court. BB. By direction by the full bench. That's persons governed by Mohammedan law, where the second and further wives of a deceased employee are entitled to apportionment and payment of family pension. Where the parties which are governed by Mohammedan law are not appropriately maintained by the eldest surviving widow, the pension will be paid. The remedy for making a claim of maintenance will be available in the appropriate program. Not a claim for payment of family pension by the state authorities directly to such persons. However, if in a given case, the state authorities of their own position are under an acceptable circumstances, the authorities are agreeable, required to pay pension separately, then finding the surviving widow. The petitioner claims to have dispatched by way of registered post. Still receipts of which are enclosed to the petition. Separate orders for that is all because of the position of the department. You can't issue a direction. So even to consider, we cannot say. Writer that out of own volition if they want to do it. But you are otherwise entitled to claim maintenance by filing for an appropriate court. Why did you file maintenance? Oh, it will take time, it will take time. Whatever time it takes, it takes.
Solve my lord, the matter will be solved, my lord.
Huh?
I hope, my lord. They are
Huh?
in that is the house, my lord.
No.
But my lord, we solve, my lord, they automatically. They are.
Department may sort it out is a different issue, but we can't issue a direction to the department to sort it out.
As per my lord, this judgment, my lord, they may look into the matter.
Under 226 only the judgment is there, but the judgment has left it open to the authorities to look into.
Yes, sir.
So there can't be a direction to look into. We can only say the grievances of the
Yes, sir.
ventilated by the representation, if they fit and proper, may be redressed.
Yes, that's
That's all. Yeah, since the grievances of the petition court considers it appropriate. Submission of the council that there is a direction. Resolve such matters relating to the party in respect of parties governed by Mohammedan law. Cannot be accepted as upon a plain reading paragraphs, the plain reading of the judgment. It seemed that the full bench had given liberty to the authority by passing appropriate orders, including separate orders for pension. Power for seeking their prayer for maintenance and the surviving widow. Respect of parties who are governed by circumstances. Directly responded authority. By the petitioner. As explained in the judgment, para 23 of the same table. Such decision that the department wishes to undertake shall not have doubts on issuance of notice. Private respondent and any other person who may otherwise be affected. Directing the respondents to sign shall not be construed to be a direction to pass effective orders by issuance of separate pension orders, if otherwise not permissible. This book. Director General of Police pass appropriate orders and place the representation before the authority decision as directed, if same is not required to be decided by the TGP itself.
Selling a transfer order dated 5/1/26, I have been transferred from Gauhati to Karnataka. My ground of I have prepared a representation that has been rejected. No reasons are exhibited there, my lord.
You are what?
I'm a constable. Constable driver.
What is your difficulty?
My lord, the wife is suffering from SLE, normally called as lupus, which is an autoimmune disease and affecting her kidney. Man.
But
SLE is very dangerous. Man. The body attacks.
Dangerous or not, but the notification has only listed these 5.
Renal failure is there.
Huh?
Renal failure is there.
Renal failure.
Yes, ma'am.
But SLE leads to what?
SLE might attack any organ, my lord. But in my case, my lord, it is attacking the kidney. Kidney means renal, my lord.
Where are the medical documents?
Medical documents start from, my lord, page 25. SLE lupus, the kidney was, there was a biopsy of kidney carried out.
25.
Page 25.
Where is the medical opinion?
The pathology report, man.
Pathology report will be
Biopsy, my lord.
not sufficient to return a clinical finding.
My lord, clinical history, my lord. SLE with lupus nephritis, serum creatinine is 1.8.
Is the composite hospital competent to examine the relatives of the services employees? Examiner and person whether he is suffering from renal failure, and if so, then he ought to be examined, he ought to be exempted under this particular circular. You are posted where?
What? And my lord, I'm at Kolkata, Howli.
Where is the composite hospital?
Composite hospital.
Have to place
And another issue, my lord, software which controls everything is extra, my lord. We are given options. I have clicked 18 options. Also, I have been no preference have been given to that, my lord. Even I prayed for my transfer, if not possible, my lord, at page 22, my lord. 5 posts I have, 5 areas actually.
Where is the order of rejection?
Rejection order is at, my lord, 24, my lord. It is rejected.
24. 24.
24, yes. Connected for page.
Where are the options given?
Options will find at page 21 the letter, page 22 the report.
Where are you transferred now?
Karnataka.
instructions. Then are the marching orders?
Marching order will be issued on 1st of April. Write that in page 20, annexure 2. Transfer will be effective from 1st April.
Sixth, third counsel for parties. The challenge by the petitioner, transfer order dated, page number.
Page number 20, 5 January.
Dated 5th of January. Made by the petitioner. So posting in Bopeta to
97
09 RAF, which is posted in Karnataka, state of Karnataka. This from criteria is renal failure.
Going to renal failure. Stop the treatment.
May have the effect of leading to renal failure. Council notification. 7 of the standing orders. Dated standing orders 04/2022, 7/9/2025. On medical grounds, some exemptions can be given to officers from booking transfer. So, further contention. 6, 5 options for his choice of posting which has not been considered. Being agreed, the present red condition is fine. Mr. CVC, appearing for all the respondents, submits that he'd like to complete his instructions. The matter. Submits the matter. State on 6
On 30th.
30. 30. Right, 30. Within a period. Very. We're asking for issuance of some allowance,
Yes,
special duty allowance.
And the State Bank of India, why don't you come to page number 8?
Let them obtain instruction.
Okay, I'm for 1 and 2 only.
1 and 2.
My road is
Who's
on.
for State Bank? No,
Oh,
no
it is-
standing counsel. Then we'll have to issue notice.
No.
Third, then it's then Gogoi Learned Counsel for the petitioner, and it's the Sharma Learned CVC representing respondents 1 and 2. comments? Depths of respondents number 5 taken by people. Industry is also permitted. 5 subject same history of the office. And an affidavit of compliance pursuant to the service effected be filed before the court. List after the returnable date, not a date to be fixed by the registry.
So in fact, the similar matters were heard by our court.
The matters have already been heard.
Yes,
Should we wait for
Which
just
we say.
are similar matters being heard?
That part, the law is on every notice that when that
Some allegations are made, you give him an opportunity under 8B.
Yes.
Right, that was not done.
Yes.
Unilaterally comments were recorded.
and those concerned, however, lordship, on the suspension order and the so-called notices, those that were issued.
The basis of these findings.
However, in this case, one more issue has stepped in, lordship. I am accused by the report. The section report was remarks have been made.
I have for issuance of notice under 8B was heard before the court had met. Huh?
That issue was heard.
That
It
issue was
was
heard.
done to suspension and so forth. Here I am trained for expansion of that.
I know, but if the court finds that the report on some ground or the other for non-issuance of 8B notices is bad, consequential order would follow for removal of the expansion or what is the effect of these remarks? The report on that ground. Therefore, I think you should await for the outcome of the judge. We'll list this matter when
Well, we are expecting the judgment on 7th of March, it was heard.
we defer it for 4 weeks. Item number
25 and 29.
25 and 29 heard MSP Chaudhary, and Mr. Lee Nath, senior government advocate. Disparaging remarks. Put the matter. And the basis of finding departmental proceedings were initiated against suspension. It's clear that these findings were recorded without giving an opportunity to take the part. Described under the condition of by private filed by the commissioner appointed that a batch of requisitions on the same legal submits that this matter will be referred. They're required to be decided. Further issues not decided by the coordinate bench are left open to be decided by this court, then matters can be proceeded. Submission of the circumstances. Matters again after 4 weeks. Counsel for the parties are permitted to obtain apprise the court in respect of any such orders that may have been passed by the coordinate bench. But
5862.
5862 of 2020. The representation exemption order
94.
where is the order passed by the respondents? Nine zero.
90.
The disease report 28/5/25. For the respondents, by the CGC, get your instructions, how the verification was undertaken. Third counsel for parties, Mr. CKS Burwa, appearing for respondents, 1, 2, 3, 4. And Mr. D. Bora appearing for 5, 6, 7. 5 and 6. We will obtain their instructions as to the manner in how. We will obtain their instructions with regard to the report submitted by the Office of the Deputy Commissioner, Karbi Angan, by the reporting. How? Inquiry as to witness of the certificate, caste certificate issued to the petitioner was carried out. Instructions will be placed before the court again on 1st of April. 1st of April. Furnish extra copies within the course of that.
Premature transfer of the petitioner, my lord, who has barely completed 15 months, and he was issued the transfer order, my lord. And my name
Where is the forest? Where is the forest council?
has been also. My name appeared as serial number 20, page 25 at 64. Devabrata Gogoi transfer to Lakshmipur as a bill. Thank you. Transfer. No, my lord. Cannot be bill transfer, my lord. Bill transfer has to be either 2 years or 3 years.
Lordship, I have the instructions. Please, sir.
I am going to record my lord next day.
There will be proceeding pending.
Proceeding PP, my lord, that has been set aside by the honorable court, my lord. And subsequent, my lord, lordship kindly see that is already set aside.
Where is the order of the court? Let them get their instructions properly. Because not just you who's been transferred. This contains several
This
persons.
contains, my lord, they are
Right.
above 3 years, my lord. I am only hardly 14 months. And I am part of the retirement. My next year,
When are you retiring?
I am retiring, my
Next
lord,
year,
September 27.
27. Still time.
Next year, my lord.
Still time. You get your instructions and tell us why this. Their instructions are that there's a promotion of 139.
Notification, my lord, there is a,
Forest
my
Link.
lord, premature transfer, they have to obtain also. my lord. That is also lacking, my lord, in the scheme. So, if then, my lord, status quo be given to me.
You produce the report. Third counsel for party. I mean, department. List of 66 officers, petitioner's name is civil number 64. Nairin, Baji to Bogamuk, SF range looking to SF range. There, superannuating in September 2027.
Annexure 3 case 26, my lord. Annexure 4. Case
This has been modified. Acha, 2 years. By the office memorandum dated 6th of August 2013. Any officer who is not completed more than 2 years of contract. Submits that to the best of his knowledge. These instructions, these approvals have not been taken before issuing the approval. According the government. Accordingly, by following the guidelines. 6th of August 2013. When can you do it?
Next week. Next week.
Next week. It's for 25th. For 23rd?
25th.
26th. Is the next week of no course effect.
my lord, I have not given the minor. In respect of the
Because someone, this is transferred to Lakhimpur to other place, but someone is coming from that place.
So without seeing the reasons, we can't give you a stay like that. This status quo will create problems. Both parties will come and say we are in the same place. No course effect. It's your home district. Then the home district, then you have to enforce the election commission guidelines. You can't be in the home district. That's the guideline. So we'll permit you to violate the guidelines. Where have you been transferred to?
From Morigaon to Nagaon.
Morigaon to Nagaon. Right? We dismiss it or you withdraw your petition. It's in terms of the election commission guidelines. Third counsel for the parties. The petitioner is before this court putting a challenge. So which order? 15 March. 15/3/2026, whereby the writ petitioner along with other similarly situated officers have been sought to be transferred out. Where is your name, serial number?
Serial number
8, your lord.
Is it in terms of the Election Commission guidelines. Show us the records on Friday. Then we'll have to give a stay. Your home district. The council for the petition merely submitted that the district of Moigaon district charge only on January 2026. Council for the Corporation Department, Mr. Bordello submits that these transfers are made in view of the Election Commission guidelines that no person in the home district should be allowed to stay. Be allowed to be posted. How submit that is instructions are not taken. Details will be taken in the next date of Kabruk is your home district. Is there any scope in the guidelines of the Election Commission?
No, in the election commission,
Election Commission guidelines. Get your instruction. Monday?
Monday.
It's on Monday, enabling the Learned Standing Council for Cooperation Department. Instruction whether the transfer of whereby the petitioner transferred from Kamrup to by the Learned Standing Council. Strict. Monday, enabling the Standing Council to complete with instructions as to whether the transfer is taken pursuant to Election Commission guidelines. Far as terms of the impute law. minimum scale of pay. Fine. Yes, what has happened now? You're not in service.
It has filed an appeal, my lord, against the order.
Oh.
My lord, there is a delay of 844 days. My learned colleague has appeared on the first day of listing of that interlocutory application, my lord.
What has happened now?
My lord, the date is fixed on 29th of April.
Okay. Heard, Mr. Rights, okay. Urge that argument before the division bench. Tell you this argument you reserve it for the division. Heard, Mr. Rights, okay. Counsel for the Mr. Arbor, respondent number
7, my lord.
7.
My lord.
Mr. Soikia submits that the directions contained in the order 5/10/2020 passed in WPC 7131 of 2021 was not carried out and the period specified. Therefore, more to the 9 of 2026, therein by order dated 11/3/2026 permitted file the affidavit in opposition. Matter has been fixed on 29/6. After so May. Yes.
My lord, in other it's to reduction of pay, and also the concern. In the meantime, on 21st, my friend or respondents wanted to file affidavit that if it is not filed properly, they have no difficulty. They want to file affidavit, file not, then the case may be fixed for admission.
Yes, who's for the respondent, who's to file the affidavit? Accountant General
For you first,
and health. Who's for the health department? Who's for the health department? The grievance of the petitioner is cessation of the pensionary benefits. Take the pension has not been finalized. Stop. This was issued by steps for recovery of amount paid in excess to the petitioner state. Extended. Stop. Respondent. You're receiving provisional pension?
Yes, sir.
The petitioners are receiving provisional. In spite of file their the health department. Have you received any papers?
Lordship, not received. Lordship, we have already returned to the department, Lordship.
The
There is a order of 18,625 Lordship.
you submits that papers which were forwarded to the accountant general were handed back to the administrative department
Page 60 of the report.
for seeking necessary clarification, which clarifications have not met. That it's the respondent authority, maybe the health department, apprise the court about the status or finalization of the pension of the requisitioner. File their affidavit if so advised. It's 3 weeks further time is granted. In the event the affidavit as directed is not filed, the court will proceed to hear the matter. 23rd of April. First week. 2nd of May. Sorry. 7th of May.
In this case,
SP Chaudhary, Learned C, Learned Counsel, and respondents. Respondent two submits that the steps have been taken
Yes.
for release of the disability pension.
disability.
And 6 further time, prays for 2 weeks further time, file amended post title. MSRR
Correspondent number 2.
Kapoti appears for respondent.
Two.
MS
It
AJN appears for respondent number 3. This again after 2 weeks on a date to be fixed by the registry after the amended post title is filed before the registry. You file the amended post title, then make amendment. Yes, where is the PNRT council? What is your instruction?
paid the allowances lordship from the date of suspension itself, lordship.
Just now through preliminary inspection I received, my client has not received any amount. The order in 10/3/2000, now it is today 18.
Give us the particulars as to how the amount has been released. Mr. I. Talukdar, counsel for the petition, appeals for the petition. MS
P.
P. Thapa appears on behalf of the PNRD. Submit that subsistence allowance with respect to the petition. By the office of the block development officer. Stop. Submits that as per instructions received today from the writ petition. Such circumstances we permit standing counsel PNRD. In case we go the court, particulars. Payment have been made. Respect of subsistence allowance the rate set. Effect of staff reports. 10th of April. 10th of April. Restoration. When was it dismissed by which order? It is on the ground of non-prosecution because he is not responded. Go and file a review against this order. What restoration? There is the finding here. Not prosecution, but because he did not respond to the repeated. Please read the order 6-2. There is a finding by the court. There is a finding by the court. So it is not going to be a restoration simpliciter. You have to recall this order. If the court has recorded the submissions made by the counsel, you are not the counsel. So you have to recall. Case was dismissed for non-prosecution, but it's not a case of non-representation. It's a case where the counsel appeared and said, I have repeatedly sought for information, no instructions have come. And in place of the petitioners, some new recruits have been appointed, petitioners not allowed to work. That is the submission recorded. That's a finding, my understanding on merit. It's not a case for, it's not a case of dismissal simplicity, non-prosecution. Dismissed for non-prosecution because you are not responded. And perhaps the new recruits have been. No, that part is not correct. Not correct, you file a review against the order. Not a case of restoration. Yes. Permitted to complete instructions in the matter. By the court. IA. This case. Accordingly, same stand dismissed. Dismissal of the miscase, however, will not. Another miscase. In view of the order passed in miscase number so and so, miscase 15 stands dismissed.
Oh, my lord.
Sir. Friday. Can come within 5 minutes, we'll take it up. Otherwise, 5 minutes only. 5 minutes by the clock. Again after what? On a date to be fixed.
Cancel.
I have mentioned the matter only Lordship for adjournment. Engage counsel.
Come on Monday or Friday.
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 Any day, Lord.
Friday. Prayer is made on behalf of the petitioner. Pass over the matter for the day. Counsel for the installment. It's agreed to list on Friday. From there to meeting.
By the department. The higher pay scale was granted to the sum of the employees junior to the petitioner.
Kindly grant the 4 weeks time for the affidavit.
Mr. K. Kunita.
That's on behalf of SK Talukdar Corporation Department.
He thus is on behalf of Mr. 4 weeks further time to complete instructions. Prayer made not objected to by the council. Staff performance. 7th April.
Final edition affidavit. Some development I have received the affidavit today. By tomorrow I will file the affidavit.
You have served him copy? No.
No, my lord. I have received it today.
Mr. MP Sharma for the petitioner, Mr. Kaur, that he filing the affidavit by today, tomorrow.
By tomorrow.
By tomorrow. Matter again after 2 weeks. First look into the affidavit. If you don't want to file rejoinder, you pray for a day. Right? Apply after.
I-17 this time lordship to obtain instruction lordship whether his service book is forwarded to the department or not. 7 this time.
It was called for from the office of the AC Lord.
Yes, Mr. Murray. Mr. R.K. Talukdar, Standing Council, Accountant General submits that in the further time be granted to take instructions. Please put this time, prayer made is not. So, 30 April.
Like, I mean, I will file my. Right.
What ground? Failed to act as per the requirement of the agreement.
Where is the is
30 minutes. My lord, at page 31. Settlement of dispute.
you have only extracted it. So bring the whole contract.
This is the GC,
CC also is not complete.
not complete, but
Railway 64.
yes, ma'am.
20%.
No,
Then that's the point. Are you disputing?
No, my lord.
Wanted to appoint your curated panel, arbitrators from the curated panel. They have not given the waiver.
my lord, actually, the contract agreement was signed before 2015, my lord. When that, this clause was not there.
But
So
that-
we are, my lord, at that point of time, we are,
Had
in
they
our-
given, did you appoint any arbitrator? Had they given any waiver? No.
no, 16, my lord. Fact is that, my lord.
Twenty-four. How many matters are there? Two.
Three.
You have to dictate an order. You're not available next week.
Yes. Next week I will be on. Next week.
You only want to pass an order
Well,
disposing of the
23rd,
matter.
my lord.
23rd, all right, 23rd. 23rd. List on 23rd and is agreed to by the council for the parties. Attempt will be made to dispose of the petition.
area due, my lord, regarding revised pay and my lord, their challenge was due at the time of retirement. The opposite party, my lord, that APR that filed affidavit, my lord, saying that because of financial stress, my lord, could not pay, as and when it become available, they are paying. This is indefinite period, that's why, my lord, why they are, my lord.
What is your prayer? Why are you not being specific? What is your prayer?
My prayer is, my lord.
What do you want from the court?
Earlier, my lord, I filed in that respect, annexer C series and my lord, B series has filed, my lord, that was pending. Thereafter, my lord, that my exact prayer is, my lord, prayer 1 to sanction and release the area pay allowance against the revision of pay scale 1996. Pay 12, my lord, to sanction and release the outstanding area DNA allowance with effect from 96 to 2014 and from 2014 till retirement of the petitioner. But in segment, my lord, if some portion has been given, if some portion has been yet to pay, because all calculation is before them, my lord. That's why I could not get the accounts, my lord. There are seven.
What is the, you are not disputing the claims. We are not disputing the claims. What is it? They have already retired, and their claim is related to the area pay, DNS allowance, pay scale, after pay scale. So when do you propose to release the amount? They are not saying the senior amount, just the present employee as well as the retired employee. Whatever fund will be available, we pay all the employees. The present employees as well as the retired. When are the funds likely to be received? The claims pertain to which year?
From 96, it's pending.
Part of the area has been paid, partly paid. Whenever fund will be available, they pay, obviously pay. But you have to make the fund available. What is it that you can't deny somebody? At least till the end of month of March, the payment of the financial year, for the see, Swami for the petition. That their mate is not disputed by the council. Not objected. Okay. Page 22. 22. Where the governor first time so to be reviewed. charge your lordship. There are no there are any objections filed here?
No, Your Honor.
Why have you filed the writ petition?
Because the suspension order in my respectful submission, Your Lordship, was illegal because it was the second suspension. They had suspended me by
Suspension in view of the contemplated review of the disciplinary proceeding.
I'm appealing from the department only, sir. First writ petition has, today the IA has come, my lord. The first writ petition notice has been issued. There, my lord, he was arrested, my lord, and under 6(2) she was, my lord, it was deemed suspension. Thereafter, my lord, after 3 months, my lord, that 6(1)(c) was applied. Again, the 6(1)(c), my lord, he has filed the writ petition. Their notice has been issued. And subsequently, my lord, this on February 2026, this particular thing, my lord, there is a power under the, my lord, under Rule 26 of, my lord, the disciplinary appeal rules, my lord. Here, my lord, notwithstanding anything contained in these rules, the governor may, on his own motion or otherwise, call for records of the case and review any order which is made or is appealable under these rules of the rules repealed by my lord, after consultation with the commission. And my lord, I am relying on, my lord, this part, my lord, provided that no order imposing or enhancing any penalty shall be made unless the government servant concerned has given a reasonable opportunity of making a representation against the penalty proposed, and where it is proposed to impose any of the penalties specified in clauses 4 to 7 of Rule 7, or to enhance the penalty imposed by the order sought to be reviewed to any of the penalties specified in these rules. No such penalty shall be imposed except for after an inquiry in the manner laid down in Rule 9, and except after consultation with the commission where such consultation is necessary. This part, my lord. If your lordship sees the page 22 of the IA, the inquiry officer and presenting officer will inquire into all charges and submit the report and findings within 1 month from the date of issue of this order in conformity with the Rule 9(6) and 9(7). Now, my thing is, my lord, let me, my lord, notice may go, and similarly in this case, my lord, I will file my affidavit whether procedure has been followed, my lord, as per 9(6) and 9(7). Your lordship allow that.
9(6), 9(7).
9(6) and 9(7) of the, my lord, disciplinary appeal rule. That is, Rule 26 says that, my lord, it has to be done as per
You are
this.
challenging this order, questioning what? There is a power under Rule 26.
Yes, Your Lordship.
Are you challenging that power?
Your Lordship, in the same cause of action, we have to provide. That is why we have
Power of there in Rule 26.
Yes, sir.
Review has to be on the same cause of action. Otherwise, it's not a review.
So, Your Lordship, in this session, we have for permission of the kindly
Paragraph 4, you know. Read the whole order.
Yes, Your Lordship. Head Constable Narendra Singh, for the short respondent, was appointed a constable. Action would amount to double 0 point. So that is my point.
This does not. Governor who is pleased to review. You are not challenging Rule 26. You are questioning that the procedure contemplated under 26 is not been followed. Judgment that you are relying on does not refer to situations like that.
No, I'm on the same course of action, the same point.
Same course of action without any movement. This is not a case of fresh DP on the same course of action. It's a case of review of the earlier punishment in terms of 20C. And before review, before then what is the how to interpret when you read
But here it has been given in the after the where pass such other orders as it deems fit.
you are trying to submit that there has to be some ground which occasions review.
Exactly.
We have, and my lord, regarding that other part, pass such other orders as it deems fit. Provide the government servant concerned has to be given reasonable opportunity of making representation, etc. My lord, all that my lord, and my lord, the last part over here. No such penalty shall be imposed except after an inquiry in the matter laid down in Rule 9, except after consultation with the Commission where such consultation is explained. So my lord, I have to now my lord get my instructions, my lord, whether this procedure will be followed on. So let me, my lord, notice may go, my lord.
Which procedure?
My lord, as per section, as per my lord, Rule 9, provided it's given. And also, my lord, representation, my lord, we have notified her. If your lordship sees the order, page 22, at serial number 6, she has been notified also. So those things they will not comply.
They fulfill the miscase. I March. It is 1st of March. Appealed order.
Yes, sir.
1st of March.
1st of March 2026. Whereby respect of the departmental proceedings, which are now being sought to be reviewed in terms of Rule 26 of the Assam Discipline and Appeal Rules. Petitioner is agreed by this order and is approached. This is by decided. What is the repetition? What have you tell us?
There you go.
second suspension order. Page 87. Page 85.
Stay.
It was stay, notice of conduct.
WPC 4861, petition 25, the petitioner has challenged the suspension order dated 5th of July 2025, whereby the petitioner was suspended. Immediate effect. Power conferred under Rule 6 within bracket 1 within bracket C of the Assam Discipline and Appeal Rules 1964. Respondent like to the applicant with AD and R. Four. Respondents complete their instructions and file necessary affidavit in the matter. Placed again after the return of the
Keep the effect. Keep the effect.
What protection? What protection? But why have you filed an IA? Why not a separate writ petition? Adjournment of the matter.
Listeners, they were all appointed way back in 2003. More than 30 years they have served, my lord. Now, if your lordship would kindly come to page number 72, my lord, 68. Now, page 72 is the order in the earlier round of litigation. Para 6. Having regard to the above and taking into account that petitioners are serving on ad hoc basis since 1993-94 and several proposals were started earlier for regularizing their services, respondents are directed to take effective steps to regularize the service of the petitioners either by completing the earlier regularization process or by conducting a press exercise in pursuant to the director's communication 11.11.6. This order is found to be justified since similar direction was given by this court in WPC number so and so. Then, my lord, if lordship would kindly come to page number 74, another batch of petition which was disposed of. Now, at page 76, your lordship will kindly see serial number 10, Haider Hussain Law School. Now, he was one of the petitioner. Earlier round of litigation, similar direction was issued that despite that, my lord, since it was not done, recently your lordship was found this order. If your lordship would kindly, this is in respect of the gentleman Haider Hussain Law School. Similarly placed. Para 4. Under such circumstances, the present writ petition has been filed. The respondents, although have filed their counter affidavit, there is no averment as to why no process for regularization is carried out in terms of the direction contained in the judgment and order it is from so passed in WPC number so and so. Then para 7. This view of the court is fortified by the recent judgment rendered by Apex Court in Jago, then Sripal,
reported in so and other similar documents, where the apex court has categorically held that extraction of service of employee by government department for years together without taking any steps for regularizing their service amounts to violation of the law. Right. Under such circumstances, this court reiterates the direction issued earlier by a coordinate bench of this court by judgment and order dated so and so, passed in WPC number so and so, and other connected with petition, and directly responding authorities to undertake the process of regularization as expeditiously as possible within a period of 120 days from the date of if required for taking into consideration the grievances and urged before this court by the petitioner and others persons who are equally rendering their services but are not available before this court. The matter of fact, my lord, this is a judgment in rem. So, I am praying for a similar order. Except the petitioner number 1 has retired, my lord. The other petitioner 12 and other petitioners, my lord, although they are serving, they are also on the verge of return. In fact, we are getting scale and everything, but if we retire like this, then we will not get the pension. So, my lord, either they regularize us or they pay us pension in terms of the OMs which are annexed to the petition.
Pension is payable to persons not regularized.
Yes, there
Where
are
is-
surplus. Yes, my lord.
Where is that?
Yes, yes. If Lordship will kindly come to first, Lordship will kindly come to page number 112. And the that page 114. A temporary government servant who retires after rendering temporary service of not less than 20 years without being confirmed in the post may be allowed the pensionary benefit as available to confirmed government servant, either on attaining age of superannuation or on his being declared to be permanently incapacitated for further government service by appropriate medical authority. This provision will come into force in effect from 1st of September 19. Then, my lord, next page also, my lord, page 119. 119. In the Government of Assam circular issued under Office Memorandum dated 10/8/83, a temporary government employee who retires after rendering temporary service of not less than 20 years under government without being confirmed in any post is to be allowed the pensionary benefit as available to retiring confirmed employee, either on attaining the age of superannuation or on his being declared to be permanently incapacitated for further government service by appropriate medical authority. The said OM came into force with effect from 1st of September 1952. The Governor of Assam is now pleased to clarify that all temporary government employees have retired from service under Governor of Assam fulfilling the criteria of not less than 20 years of continuous service will be eligible for pension from 1st of September 82 onwards. There is one more, my lord, at page number 121. On 6th of September 2003. In continuation of this department's OM dated 12/9/96, which I read just now, it is reiterated that said OM clearly lays down that a government servant retiring 20 years of continuous service without being confirmed shall be eligible for pension benefit. The focus is on 20 years of continuous service. After ending 20 years of service, if government servant is superannuated or incapacitated.
Their serving is what?
Pillar.
What are they serving in?
We are all below grade 4 staff.
As what?
Some are instructor. In
So
the,
how do you what do you say regarding this Pendas judgment, where there is a categorical finding?
No, Upendas, my lord, this aspect of the matter was never gone in. In fact,
No,
Upendas is not a judgment which is rendered on merits. Upendas is a case, my lord, by humble submission, where a concession was given by him. In the midst of the
whatever
hearing,
it may be, whatever it may be, but it's a finding where the court has done the finding, saying that master roll workers temporary employees are not entitled to regularly. Finding.
all right, regularization, but as a temporary government servant, if I have served for 20 years, as per the government circular, we are entitled to pension. Because Upendas and all these people, they were not getting any scale of pay. They were contractual income. They were getting a fixed fee. Here we are getting regular scale. And we are
There
working
is a
for,
judgment passed by this bench.
in fact, the judgment which I have given, you will also give any direction.
But there is another judgment.
You know, whether I am regularized or not, I am more interested in my pension, to be honest. Because since I have already served, since I am getting my increment, otherwise also I will get the monetary part.
What do you say, Mr.
Not we have kind of affidavit. One thing is that I agree, but this is the document we are seeing that your case. Review, madam. Against the order dated, madam, is the WPC number 6021. That is pending, madam. Regarding madam pension, thus we have to be a government employee. Leading the government servant. That's not all, madam. Yeah, basically, madam, ad hoc employee.
Status of the review.
Instead of review, madam, there is a delay, madam, of 12 years, madam. That has to first follow, madam. Explain the delay, madam, for the delay. Why it is delayed.
Here we are basing our case on the circular of the government of Assam. It is not their case. That
Where is your appointment order?
Yes. Page 34 onwards. Similar, these are appointments, page 34. See, Digan Kolika, village so-and-so is appointed temporarily junior instructor machinist in scale of pay of so-and-so plus other allowances under the rules and posted at IIT Nagaon against the existing vacancy till regular appointment is made.
So this appointment remains?
Yes, the contrary.
It is not extended or anything?
It remains, below. Extended. Some of them are extended. We are getting a regular salary, we are getting increment, everything. Only thing is, my lord, will retire tomorrow. In Upendas and all, those who are, my lord, casual employees getting a fixed pay, 900 or something. So this is not our cases like that. Now, the government's own decision is, whosoever temporary government servant who is put in 20 years is eligible for pension.
No, that is if you are a government servant.
Yes.
My question is,
I'm a government servant, my lord. I'm getting a scale of pay.
Scale of pay is all right. But if you are a government servant, okay. But against an existing vacancy,
Yes.
till regular appointment.
Yes. And again, existing vacancy. So against a sanctioned post. And my lord will kindly see, my lord, we as a grade 4 or grade 3 employee, where do you have that bargaining power to, my lord, argue with the government, why are we getting this type of appointment, why not that? That is what has been said in Sripal and Jagua and all these cases. These are all exploitation, nothing else. The fact that our services are being utilized goes to show that there is a requirement. Ideally,
there is a judgment passed by this bench. There is a judgment passed by this bench, not this matter.
Okay.
Other matter where the issues were considered, including Upendas and Jago, some directions were issued to the government. That the
That,
yes, can get it from the court master.
I'll get it. But can I have the matter next week, you know?
But check with that review, my lord.
Serious.
First, let us deal with one matter. Why are you clubbing up all these matters? Let us understand what orders will be required to pass. Request made by the council for the respondent. This again next week or week after?
Next week, Miller.
Next week.
Wednesday.
25th. 25th. It's on 25th. Respondent number 1 and 2. 1 and 2 SK Medi for the CKS Murwa for.
Take the copy.
Yes, you can get the numbers, I think.
So I'm appearing for the respondent in this case. Before my learned friend starts, I feel there is a legal issue that based on the very maintainability of this petition. If I may just apprise your lordship on that. Your lordship takes up the application under section 11 that has been filed. If your lordship will see the contract document, page 16. What has been annexed as annexure 2 is purportedly a contract. Now, lordship will see the pages. It starts at page 1 at the bottom. Page 1, page 2, page 3, page 4. And then at page 20, now lordship will find it starts at page 13. From page 4, we have skipped to page 13. And after that, a few pages have been annexed. And that is the end of the contract document. Now, if your lordship will come to the scheme of arbitration, if I may place the scheme of 1996. So this is a precondition that a lordship has to look into before lordship assumes the jurisdiction, whether the scheme has been complied with or not.
Section.
Under the scheme, clause 2, lordship. The appointment of arbitrator by the Chief Justice of India scheme 1996. At the back of the arbitration. And this scheme is also, as is found as Appendix 23 of the Gauhati High Court rules. The mandatory scheme also. Got that? Clause 1. This scheme may be called the appointment of arbitrator by the Chief Justice of India scheme 1996. Clause 2. Submission of request. The request of the Chief Justice to the Chief Justice under the subsection 4 and subsection 5 and 6 of section 11 shall be made in writing and shall be accompanied by, we are concerned with A, the original arbitration agreement or a duly certified copy thereof. So it can be either the original document or a duly certified copy. Now, if your lordship will see why it assumes significance, because lordship will kindly come to clause 6 now. Next page, clause 6. Rejection of request. Where the request made by any party does not fulfill the requirement of paragraph 2 of this scheme, the Chief Justice or the person or the institution designated by him may reject it. Now, this also assumes significance for because of a constitutional division bench judgment, wherein apart from addressing on this aspect, the Supreme Court has also said that if that document, it opens spectrum. If that document that is before your lordships happens to be an unstamped document, this is admittedly an unstamped document, then under the Stamp Act, since it requires stamp registration, stamp duty has to be paid, the Honorable Court, the High Court under 11 has the authority to even impound that document. And the Supreme Court has also said that that document cannot be deemed as a document that is in existence in the eye of law. Categorically, it's said.
But also says unstamped document. There is an agreement for arbitration. There is an unstamped document. Even if the parties to the
if I may therefore place this judgment, because I got the judgment yesterday night only when I was looking at the aspect. This judgment categorically deals with the fact that it is duty of the Honorable Court under Section 11 to see that only the
you are
physical.
reading from the majority view.
Yes. It says that merely existence of that document on record in the exterior form will not do.
Referring to
NN Global Mercantile Private Limited.
subsequent thereto, there is a
I was just reading this judgment yesterday, so I was basically seeking for some accommodation on that aspect also, because this, in my understanding, this indicates that if it is an unstamped document, the court cannot rely on that document.
First of all, these are not their meetings in their
This is
affidavit in
the point of
opposition.
law. This is the point of law.
Now, even if it's a point of law, there is no dispute as to the existence of an arbitration agreement. If there is no dispute as to the existence of an arbitration agreement,
Satisfaction has to
And
come from
then
the court.
no, if there is no, the burden doesn't lie on the
If it is an unstamped document, that is my question. Because the Supreme Court judgment says it cannot be taken into consideration by the Honorable Court. Subsequent judgment, I have no knowledge about that, but I was just going through this and I thought this is something important that I should place what is honorable. In fact, paragraph 110.
you are referring to the
This is 2023
two judge bench judgment.
Constitutional. Yes, sir. 1, 3, 4, 5. This is 2023 7 SCC page 1. I apologize, I have the book with me, not a PDF copy. Therein, in that judgment, paragraph 110, from paragraph 110, page 81, it clearly brings about this aspect, and thereafter the discussions continue. And finally, the conclusion is
this other judgment. Interplay between arbitration agreements and the Arbitration Act and Stamp Act. It's 2024 6 SCC page 1. Six SCC page 1.
I have not gone through. Therefore,
Seven judge constitution.
Therefore, if Lordship accommodates me for some time in this matter, I really wanted to deal with this aspect, but I didn't get the time to go through the entire thing.
Please do. We'll give you sufficient time. Mr. Senapati, you go.
That he can also address the court on this aspect.
You are raising the objection.
I understand, but he will be much more competent to deal with this issue.
Why are you considering yourself any less competent?
In arbitration before him, yes.
Then why should we hear you at all?
Because I have a relevant point.
So, hold on. Say to any
What has gone against it?
Huh?
Yeah, that's wrong.
point now.
I'll do that. I'll do that.
Right.
Hearing this.
Second.
Take it up on me.
7th of April.
7th April.
7th.
7th. It's agreed to by the government.
Obliged, Your Lordship.
I never,
Filed it.
we will file it.
No, the affidavit in opposition has been filed by the Union of
Counsel for the counsel for the General seeks liberty to file rejoinder affidavit to the affidavit filed with the respondent. She pays for 3 weeks. 3 weeks time. The prayer is not objected to by the respondent. Who's the matter?
I'm supposed to take inspection law. I made a request to the treasury officer to send back the both the halves. So petitioner has to also approach the treasury officer for the one half. Only if this two are received, we can only proceed. Also. Let the petitioner approach the treasury officer.
You want both the half for what?
It has to be given that
For what?
to issue the fresh one in her name.
Family pension.
Now she will get as an unmarried daughter.
CGC
Standing counsel
appearing
account.
from the accountant general office submits that the treasury officer, Kamrup Treasury, has been requested to remit both the halves of the PPO number 3373 in respect of Jamini Kanto Sarkar, late Jamini Kanto Sarkar, ex head warder, in original along with the last payment certificate mentioning the rate and the date of last payment to enable the office of the accountant general for release of pension by the eldest daughter deceased, claimed by the unmarried daughter of the deceased, namely Miss Pompa Sarkar. The counsel for the petitioner submits that she will also approach the treasury office for early remittance of the both halves of the PPO, the office of the accountant. After 4 weeks. After 4 weeks, you make a mention.
Okay.
the issue pertains to the release of CRD.
Yes, PWD, why not have released it? Why no have you not released it?
Find out affidavit.
Huh? Released.
We have produced.
DCRD,
my lord, here is a confusion, my lord. Why? Because
They filed opposition. You want to file
no,
rejoinder?
everything is clear. They have already admitted the amount I am entitled for that. Because they are affidavit for different establishments. They are saying that I am entitled for that amount. Now it is the interdepartmental confusion. That's why they are not releasing that.
Filed with the finance department. That's one number 3. Specifically mentioned the provision is office memorandum, page number 41. The request that I have entered for the DCI. Also there, page number 41. Add to 41, page number 38, loss is the calculation of done by the DDO. The 27
So who is to release the amount?
Yes, sir, is to
Why is it not being done?
Paragraph 5. Does the as regards the paragraph petitioner himself admitted that he had deferred service as section 8 worker, but his service was not regularized by the competent authority. So far as office order number 7 dated 29 February of non-regularized workers who are not entitled to any pension or pensionary benefit on their retirement expiring may be granted gratuity in terms of Rule 150. As per 153(2) of the Assam of the Services Pension Rules 1969, the petitioner is entitled to 1 year's pay only, but the executive engineer PWD Sri Bhumi NH division sanction 7,56,612 in favor of the petition. So, as regards the amount, there is dispute law. Thus, the action of pointing a memorandum against the gratuity claim in respect of the petitioner is not illegal and arbitrary. We have pointed out the same thing to the executive, the treasury officer. The undersigned has given a memorandum to sanction the admissible amount of gratuity in favor of the incumbent petitioner, but no sanction or claim has been presented at this treasury by the drawing and disbursing officer till date. So that is the issue law. And so far as GPF is concerned, that has already been released. If lawsuit comes to page 35. Page 35, paragraph 12. GPF amount has been cleared. As far as gratuity is concerned, lordship, no claim for entitled gratuity in favor of the petitioner has been presented as this filing. This instruction was received in the month of November 2020.
That is the admission.
Also, can you see the page number 9, paragraph number 9 of that particular affidavit? That as regards to the statements made in paragraph 14 of the petition, the deponent states that as per Rule 14 of the Assam Treasury Rules 2017, the Treasury officer has no general authority to deal with the demands presented at the Treasury. Prescribed for the purpose. So the allegation raised by the petitioner for not the action taken by the undersigned is in order. The petitioner is a non-regularized worker member. He is entitled to 1 year pay as service in terms of Rule 150. You are claiming that thing, 1 year, because the calculation is there at page number 38. If they are saying that I am entitled for that 1 year, why they are not taking that amount? Page number 38 is the specific calculation which is going to be 1 year. But can you see the page number 38?
But there is some sanction or claim has to be presented by the drawing and disbursing officer, PWB. Executive engineer.
Lordship kindly see the annexure A, that is the page number. Annexure A page 37. An amount of rupees 7,56,612 only is hereby sanctioned as death cum retirement gratuity. You see footage of the retired WC section assistant of after rendering 20 years.
But has it been sent to the Treasury Office?
Exactly, Lordship. Kindly see this copy. The account.
Treasury Office.
The
It is sent,
Treasury Office.
Mr.
Yes, that is what I'm pointing at. Page 33, Lordship again. What may be, I mean, the wordings may not be proper, Lord. If Lord page 33 does the second paragraph, Lord. Second, I mean the sub-paragraph of the first paragraph. Does the action of appointing a memorandum against the gratuity claim in respect of the petitioner is not legal. Has returned it, Lord. In fact, the proposal was submitted. According to him, Lordship, he has given a page 40, Lordship, from page 40. Pension and gratuity. I mean, service period is more than 33 years.
Why? Is there any objection orders passed by the Treasury Office?
Yes, Lord.
Where is
This
that?
appears, Lord.
Where
From
is
this
that?
paragraph, Lordship, page 33, it was returned, Lordship. That letter has
No,
not
that
been
was returned. Why was it returned?
according to the treasury officer, this is not the correct amount. The calculation is not correct. That is why he returned. That is why he states, Lordship, does the action of pointing a memorandum, I don't know how this.
So according to the Treasury Officer, what is the correct amount?
According to the treasury officer, Lordship, is paragraph 4, Lordship.
So according to Treasury Officer, he is
According to the
entitled
treasury
to
officer, Lordship, he is entitled to 1 year. I mean, that amount has been mentioned, Lordship.
1 year's pay.
Yes.
So 1 year's pay
30,
is shown here.
page number 30.
As per 153(2) of the Assam Service Pension Rule, the petitioner is entitled to 1 year's pay only. Lord Lordship, according to him, probably this calculation is not correct. That is why it was returned.
No, but he has to specify why which part of the calculation is incorrect. What is incorrect?
That letter has not been annexed.
This particular calculation reflects. This calculation reflects that it is calculated for 12 months. It's 12 months pay.
12 months.
One paragraph is there, Lordship, one paragraph 4. Stated that he has attained like that the total length of service. What difference does it make? Calculations are there. If Lordship comes to page 40, Lordship. 21 years and above, Lordship.
Page 40.
Yes. Pension and gratuity. 31 years above, Lordship, then the amount will be 1 year's pay plus 1 month's pay for each completed year above 30, subject to a maximum of 6 months pay. And if it is less than 30 years, Lordship, then the amount is different, only 1 year's pay. If it is less than 20 years, Lordship, 6 months pay.
So he according to him, he falls in
So
category 4,
yes.
31 years. But according to Treasury Office, he falls in 21 to 30 years.
Not exactly what was the deficiency found by the treasury officer, but that is not this evidence. That difficulty I am also facing.
No, page number 38, Lordship, they have calculated on that way, Lordship, 1 year service. What my learned friend is showing with regard to this page number 40, that has been calculated in page number 38.
Pay includes grade pay and DA.
Yeah.
calculate.
Exactly.
Let me have that instruction in
The
that
last
situation,
order is
doctor. I am
also
not
there,
praying
that
for
will
much
instruction.
time, doctor. Will grant me 2 weeks time, doctor.
2 weeks. On the last occasion, Lordship kindly say the occasion. Lordship kindly the last occasion, several locations this time has been taken on the text of.
You just get a clarification. All your treasury officer get instruction.
Monday.
Have it on 25th. 25th. Hard work. For the respondent.
Otherwise, like this, covered by the earlier contract. There was some delay, and that delay I could not explain in my writ petition. Thereafter, I filed an additional affidavit, and it was a medical ground, my lord. Medical reports I have submitted. An additional affidavit.
When was the selection? 2021. Why have you come now? Where is the explanation for delay? Paragraph, which paragraph?
I will switch.
Can't be ground for approaching the court for your appointment. How would you, supposing you were selected?
Yes.
How would you have gone and joined your forces if you have to look after your mother, father, uncle?
No, now they are okay, my lord. At that relevant time.
At that relevant time, supposing you were selected,
Yes.
how would you have gone and joined? As per your explanation for the delay,
Yes.
which means you were not medically fit.
No, I am medically fit.
No, you have also stated some
one of the
problems.
He was guest
Whatever, there was some medical issues.
That
Now, assuming that we go back to the date of selection,
Yes.
keeping in view these medical certificates, you're not fit to be included.
One petitioner that gastric problem was there, my lord.
Then-
Now he is okay, my lord.
Now he may be okay,
Yes.
but how would he have joined
But-
then?
For that, my lord, I have explained.
4 years delay for appointment petitioners, the respondents may have been all have been appointed.
No, 21 the list was published. And on 24 this petition was filed. 25 this petition was filed. So there's 4 years delay, my lord.
That's right. You are asking for appointment
Yes, my lord.
in vacancies which have been picked up.
Yes.
Now you'll have to array those people who have already joined, make them parties.
No, my lord, there may be vacancy. Direction there is part, my lord.
Maybe some vacancies may not be entitled to those which spill over to the next election process.
But my lord, last order, my lord, we have done vacancy regarding the vacancy. The court has passed the order. If there is vacancy, I may be accommodated, my lord.
What is last order?
Page 83, my lord.
not available. Last line, my lord. However, if the vacancies are not available, then that event.
As whole council. File there rapidly. File it. Ten four. Master first of April. Mr. R.K. Sharma, learned counsel. Liberty to complete instructions in respect of the additional evidence filed by the respondent bank. He prays for